Right, good evening all. So welcome to our contract law Q&A. I see we've got 7 people watching, so that's a start, that's good. Thanks very much for your interest. So what I suggest we do is I will just talk about each of the topics that we've covered on the course which are examinable. And as I go through those topics, you can ask questions, you can post questions, and then I'll deal with those in turn. And I'll spend a bit of time talking about some of the cases in particular in respect of common mistake. Alright, so we started off the course when 10-11 weeks ago, and we started off with the whole notion of mistake, the Doctrine of Mistake in contract law. And basically, we subdivided that into 3 types of mistakes. So there's common mistake, and unilateral mistake, and mutual mistake. So those are the 3 types of mistake that we covered, and then there was also documents mistakenly signed, but we're not going to examine that on the exam. So, in respect of common mistake, we basically subdivided that area, again, into 3 different sub-areas. So, 2 of them were very easy, res extincta and res sua. The thing is already his, or the thing is no more, the thing doesn't exist anymore. So we had a few cases. That was all very straightforward. The sort of more difficult one was the third one, the third category of common mistake, which was common mistake as to quality of the subject matter. And in essence, we had a sort of a number of cases. There was a sort of development that we could follow. It started really with a case called Bell and Lever Brothers. And as you will recall, in Bell and Lever Brothers, we had an employee, Mr. Bell, who was also the manager of a company that was part of the Lever Brothers organization. By the way, Lever Brothers then later on merged into Unilever, a very big company that we know today. And when Lever Brothers merged with another company, they were they had to sort of reorganize. So they had to release Mr. Bell from his contract. And he had a contract which ran for, I think, 5 years or more. So it ran for a long time, and so they agreed to compensate him. And so the way they did that was that that often happens when you have a contract, an employment contract, and you want to dissolve that employment contract, then you have another contract to dissolve that first contract. So it's basically a dissolution contract. And so as part of the dissolution contract, Bell was to receive a very large sum of money. And so they agreed to that contract, both parties agreed that there was a contract, and then later on, Lever Brothers found out that Bell had actually not always done what he was supposed to do. In fact, while he was the director of the company that he was supposed to lead, he had engaged in some, he didn't follow his duties, should we say. And but that's not the crucial part here. The crucial part is that what he did would have allowed Lever Brothers to fire him on the spot. So when they found out about this possibility of firing him on the spot, Lever Brothers said, well, we're not going to pay you the money we agreed to pay you because we could have fired you on the spot. And the whole thing went to court because, of course, Bell insisted on getting the money that had been agreed. And the court held that Bell should be entitled to receive the money. Now, why? Well, if the contract, and by contract I mean the dissolution agreement between Bell and Lever Brothers to dissolve Bell's employment contract, if that contract was to have come to an end, and if that contract was not supposed to, if it was to have come to an end as a result of some wrongdoing of some sort of, if there's a sort of a legal justification for it, one legal justification might be common mistake. And so the argument could have been, or the argument could have been made that the parties were under some sort of misapprehension and that a mistake was made as to the contract and whether it could be dissolved that way. And of course, Lever Brothers argued that they made a mistake because they thought they were negotiating to let Bell go, and to do that while they were going to pay money for that. But later on, they found out that they could have let him go for basically no money. They could have just fired him on the spot. So they thought that they were negotiating about something different than turned out to be the case. And then you would have had a mistake as to the subject matter of that, or the quality of the subject matter of that contract. But the court didn't agree. The court said what the parties negotiated about was the dissolution of Bell's employment, and that's exactly what the parties got. So the only difference really is that in one case, getting that would cost Lever Brothers a lot of money. In the other case, it would have cost Lever Brothers a lot less, or in fact, no money at all. But that's basically just one characteristic of the contract. That's not the essence. That's not the heart of the contract. What's at the root of the contract? At the root of the contract, the court held was this idea that you wanted to dissolve, or parties wanted to dissolve the employment relationship, and that is exactly what parties got. So no common mistake as to the quality of the subject matter. And if you think it through, and in fact, in the case you'll see there's a list of hypotheticals which the court sort of considered when would a contract come to an end because of a mistake as to the quality of subject matter. And the court basically determined it's going to be very difficult to show that the quality of subject matter changed in such a drastic way as to mean that there was indeed a common mistake. Because essentially what you have to show is that whatever lies at the root of the contract, the parties had some misapprehension about that, where the parties thought the root of the contract was this, and then it turned out to be something different altogether. And of course, in the case of Bell, it wasn't different. It was the same. Whatever they negotiated about, the dissolution of the employment contract, is exactly what they got. So that sort of, in a way, shut the door on a lot of potential cases. And so 18 years later, in fact, this issue came up in many cases, but 18 years later in Soul and Butcher, there was a sort of a big change, because what happened in Soul and Butcher, this was a case about rent control. So two parties had agreed on, the landlord and a tenant had agreed on renting a premises. And they were under the misapprehension, both of them, about the whether that place of rent was controlled, was covered by rent control, or whether it wasn't. And so that then became a question for the court as to whether that misapprehension is a common mistake as to the quality of the subject matter. And the court, again, on the common law side, found there was no mistake, because the contract at its root was about renting this premises, and that is exactly what parties negotiated for, and that's exactly what they got. So there was no change there. The only change was in the actual rental value. And of course, the rental value is just one characteristic. And the fact that one of the characteristics turns out to be different from what parties expected doesn't mean that you can claim common mistake and then have the contract be declared void. But, and here's the very important thing, the court said that even though it was valid at common law, there may still be a remedy in equity. And in fact, the court then offered the parties in Soul and Butcher a way basically of either affirming the contract going ahead or ending the contract on the basis of equity. And in essence, what the court established was a separate doctrine of common mistake as to quality of the subject matter in equity. This was controversial. It was also controversial not only based on the legal reasoning, but also on the fact that Bell, of course, was a House of Lords decision, and Soul and Butcher was a Court of Appeal decision. But nevertheless, it sort of offered an attractive way of going forward, or of at least offering some sort of remedy. And then we had a number of cases all the way up until 2002, so for about 52 years, that all kind of adopted that model where even though the contract is valid at common law, the court would still explore whether there's a common mistake as to the quality of subject matter in equity. Now I see we have a question here, so let me just have a look there. If we wanted to make a mention of where in Bell and Brothers equity was mentioned, how would we go about doing that? I know Lord Atkin mentioned it using Smith and Hughes and Lord Martin. All right, so this is a very good question. So one of the reasons that Denning and Soul and Butcher said that the Court of Appeal in Soul and Butcher was basically allowed to come up with this new doctrine was that the issue of equity had not been considered in Bell. And so Denning argued that the court in Soul and Butcher had completely followed Bell, had done everything that they ought to have done under the normal rules of applying precedent and from a higher court, of course. But because Bell hadn't considered the equity side, it was free for the Court of Appeal to do that in Soul and Butcher. And so the question, which is a very good question, goes to the point that if you look at Bell and Lever Brothers very closely, you'll find that there are a number of instances of precedents from equity being brought up, and some of the counsel in that case talking about equitable principles. So there's not much, but there are some instances of that. So to say that Bell had not considered, in Bell, the House of Lords in Bell had not considered equity, that would simply be wrong. They did consider it. The only argument I suppose one could have is to what extent did they consider it. But the fact that it was considered should have really foreclosed any opportunity for the Court of Appeal in Soul and Butcher to sort of bring it up. But nonetheless, that is what happened. And so that, because it was such an attractive solution, we saw a lot of cases that kind of use that same approach. The situation from the common law first, and you would usually say that under the common law rules, there is no common mistake as to quality of subject matter because whatever is at the root of the contract hasn't changed. So if it hasn't changed, then of course that's not available. We can't declare the contract void for common mistake. But then to move on to the equity side, and then to hold that the contract is indeed that there is a remedy available through equity, through what some people describe as a doctrine of common mistake as to quality of the subject matter in equity. So that went on for about 52 years, and then we got to the Great Peace case, also Court of Appeal. And what happened in the Court of Appeal in Great Peace was that the court had to consider factually a very different circumstance from the rent control issue in Soul and Butcher, very different from the employment situation in Bell. But if you really think about it, essentially it's the same thing. So the Great Peace was about, you can look up all the details, I'm not going to go through all the details again, but about a ship being hired to help another ship. And so one ship was stricken and another ship was hired by the stricken ship to help out, or kind of to be on standby in case that stricken ship sinks and needs to be urgent aid and help. The mistake that the parties made was not about the help per se, it was about the distance between the two ships. As it turned out, the second ship, the one that was supposed to help the stricken ship, was further away than the parties thought. Now, is that a common mistake as to subject matter? And the court again looked at the root of the contract. What lies at the heart of that contract? And what lies at the heart of the contract, again, very simply, is a contract for one ship to help another ship. Now, as to how long it would take the second ship to help the first ship, that's one of the characteristics, but it's not what lies at the root of the contract. And even though the distance was longer, the second ship was still able, or would have been able to help, because they would have been able to reach the stricken ship. It would have just taken longer, but they would have been able to help out. The whole contract was supposed to be for 5 days, and they would have been able to, I think, cover a majority of that time. Now, so again, the court held that there was no common mistake as to quality of subject matter at common law. But instead of moving then on, like all the previous cases since 1950, and looking at the equity side of it, the court said, we don't need to do that, because the court has already found that at common law, this contract is valid. And if it's valid at common law, then why would we need to go on and consider equity? And so they said that Soul and Butcher was basically a wrong decision. It should have never gone on to the equity part after it found that the contract was valid at common law. And so we went back, in terms of ratio, we went back to Bell, and that is essentially where we are now. All right, so we got another question. I couldn't find a case definition for mistake, which I think would be helpful in writing a good discussion. Is there a case that defines it? I think all of these cases sort of define it in some way. I don't think there's a case that sets it out for us. So recall that, and we come across this a lot. So sometimes we're kind of lucky when we look at common law, not only contract, any kind of common law. Sometimes we're lucky because some judge at some point, 50 years ago, 100 years ago, whenever, had the sort of presence of mind to sit down and say, well, these are the rules and these are the headings or these are the tests or whatever. And in Mistake, we don't really have that. What we have is we have a number of cases, and we just have to look at all of them and try and find commonalities. So, for instance, you'll find that in a lot of these earlier cases, say from 80 or 100 years ago, the words common mistake and mutual mistake are sort of used interchangeably, which is not correct. But that just goes to show that there wasn't, at least for a long time, an agreed classification and agreed nomenclature. It was kind of, the judges just went along with calling it mistake. I think the easiest way or the best way just to think of it is common mistake means that both parties make the same mistake. I think that's just the best way to go about it. And if you need a case to define that, well, I think all the cases we just discussed would tell you that. Mutual mistake, which is the one we're going to move on to now, is where there is no meeting of the minds. That means both parties make a mistake, but it's not the same mistake. So in common mistake, they both make a mistake and it's the same mistake. In mutual mistake, they both make a mistake, but it's a different mistake. And so for mutual mistake, we have you always remember this, peerless from Bombay. Remember, so there was a contract that stated the goods will be on a ship, and the ship will be called peerless, and it sails from Bombay. So these three words were in the contract, peerless from Bombay. It's just that the buyer thought it was the peerless from Bombay in October, and the seller thought it was the peerless from Bombay in December, because as it turns out, there were two such ships called peerless, and they both sailed from Bombay, just at different times. So there was just no meeting of the minds, and therefore that contract was void for mutual mistake. So that's fairly easy, fairly straightforward. And then for unilateral mistake, only, as the name suggests, only one party makes a mistake. So instead of, for mutual and for common, we had a situation where both parties make a mistake, and unilateral mistake is just one party that makes a mistake. All right, so we've got another question. In relation to the case of Frederick, E. Rose, William, and Harrison, Jones, Lancaster, and Soldier, those bank cases, where would they fit into the timeline? All right, so you just have to look at those. I mean, I think the first cases you mentioned there don't really fall into that timeline at all. Associated Japanese Bank does, but Associated Japanese Bank is a fairly complex case, but that falls. It is not really decided on the basis of that timeline strictly, because it never went into the equity part, and that is because it's one of those rare cases where indeed there was a common mistake as to the subject matter. So where it was able, where the parties or one of the parties was able to show, in fact, that there was such a mistake. So remember, in most cases, that's not successful. In most cases, it's very difficult to show that, to prove that. But in Associated Japanese Bank, it was possible. So of course, once you prove it, and then the contract is void for common mistake, then you don't need to consider the equity part at all. Now, in the other cases are older cases. I don't think they fit into this timeline. So because you mentioned the Associated Japanese Bank, so what happened in that case, common mistake, is that we're talking about a situation where this is a contract between two banks. But the situation involved a crook, a criminal, who basically defrauded the first bank because he took out a loan to buy some machines, but these machines never existed, so he just took the money and ran off. And when the loan was taken out, it's sort of standard procedures for banks to then reinsure themselves with another bank. So the Japanese bank went to another bank, and Credit du Nord, and they said, well, would you reinsure us just in case this guy doesn't pay his installments? And so that's a very straightforward, normal procedure amongst banks. And then, of course, the guy ran off, and the Japanese bank said, well, okay, that's not good, but at least we're sort of reinsured ourselves, so now we can get the money back. I think it was £1 million, and the court held that there was a common mistake. So the contract, that means the contract between the two banks, turned out to be void. And the reason why there was a common mistake is because there was a genuine misapprehension about what lay at the root of the contract. What was the contract about? What was at the heart of the contract? So remember, every time so far when we talked about it, the employment or the rental or the ship, helping the other ship, every time we said, well, what the parties thought they were agreeing on turned out to be exactly what they did agree on. And here it wasn't so it wasn't the case, because what the parties thought they were agreeing on was that they thought they were agreeing on a reinsurance contract in case installments are not paid for the loan to buy machines. But that last part, the buying machines part, is very crucial, because what they got is reinsurance for loan payments of non-existent machines. So on the one hand, you have reinsuring for in case a party doesn't pay for existing machines, and in reality it turned out that these machines did not exist. So the court said it's not just a contract for reinsuring against the failure to pay loans. There must be something more, because otherwise, of course, the contract wouldn't have been agreed. So that did lie at the heart of the contract, and then because that was then not the case in reality, it turned out that that was a common mistake. All right, so unilateral mistake, I think you can look at the cases. That's where one party makes a mistake and the other party knows about the mistake. And we looked at a number of cases. Usually this relates to mistake as to identity, and there's a 3-stage test which you can look at. All right, then we talked about misrepresentation. I think misrepresentation, sort of in the greater scheme of things, is probably a bit easier than mistake. In particular, this whole notion of common mistake and the sort of development of the law on that, so where we had these changes and then we went sort of back again. Misrepresentation is more straightforward. Misrepresentation is really more about applying the knowledge you have about the 3-stage test to some sort of scenario, some sort of fact scenario, or laying out how these tests work, or how this 3-stage test works. But I think the fact scenario, that's if there's sort of some difficulty in misrepresentation, it would be in that, or of course in real life, deciding whether something is or is not misrepresentation. So you have a 3-stage test, you go through the 3 tests, and usually 1 or 2 of the tests will be very easily proven, very easily shown, and then maybe the 3rd one will be a bit problematic. So remember, the first one is whatever the misrepresentation, the alleged misrepresentation was, must relate to a past or an existing fact. Now, whether something is a past or existing fact seems to be very easy and straightforward, and we can easily sort of ascertain that. But I think in reality it's not that easy, because sometimes sometimes it is, but when you come across a situation, we had many different scenarios we looked at, where someone makes a prediction about the future, or someone puts out an ad, or someone makes a statement about the law, or someone gives some sort of opinion. So for each of those, there are kind of specialized rules that we looked at. For instance, in terms of opinions, it is only a past or existing fact for the purposes of misrepresentation if the person who gives that opinion has some kind of expertise in that area. And so we had Bissett and Wilkinson, where this was for the sale of farmland, and the question the buyer had was how many sheep the farm would hold. But the seller had no knowledge of that, because the seller had never kept sheep on the farmland. So the seller said, well, I think 2,000. I think 2,000 was the number. And then later on it turned out that was too high, that was not realistic, and a claim was made for misrepresentation. Now, is that a misrepresentation for the purpose? Well, does that satisfy the first test? So when the seller said 2,000 sheep can fit there, is that just an opinion, or is that a statement of fact? And because the seller did not have specialized knowledge about sheep, it was just an opinion. Now, if the seller had knowledge about sheep or had kept sheep, then it would have been a statement of fact. Okay, so the first thing you need to prove is it a statement of fact? Okay, so sometimes it's quite easy, and sometimes, like in the sheep case, you have to think about it a bit. The second one also seems quite easy, but sometimes you have these tricky situations. So the second test is the statement must be untrue. And usually you can immediately tell whether it is untrue or not. But sometimes, where you have something like a half-truth in Dimmick and Hallett, where you say, well, we have existing tenants, which is technically true, but if the tenants are sort of about to leave, then you've kind of left out that second part, so you've only told a half-truth. And so half-truths for the purposes of misrepresentation are basically lies. Or the same happened in the Spice, well, not quite the same, but something similar happened in the Spice Girls and Aprilia case, where the Spice Girls had failed to tell Aprilia, who were running the ad campaign and were paying a lot of money for that, that one of the Spice Girls was leaving the band. So while the ads were done, the Spice Girl, Jerry was still in the band, but then later she was going to leave, and that was already known at the time. So it's a bit similar to Dimmock and Hallett, where it's kind of a half-truth. So half-truths are untrue for the purpose of misrepresentation. So someone, all right, we've got a question here. All right, so in terms of existing facts, so what happens, the question is about Chao San San, which is a case about something prospective, forward-looking. So the general rule when you make a statement about something in the future is that you cannot be held to it coming true because it's something in the future. It's not a past or existing fact. The only limitation is that whatever it is you say about the future must be a genuinely held belief. You can't just lie about it. So in Chao San San, the parties, this was about the sale of an apartment which had not yet been built. So it was basically, you saw the plans and you bought, so the buyers bought the apartment without seeing the real thing, just seeing the plans. And in the brochure it mentioned that apart from the apartment there would be some tennis courts or squash courts. There would be sort of some amenities. And then some of them were, in the end, were there and some of them were not there. And then the buyers claimed misrepresentation. The point was, the court said it was not misrepresentation because the sellers, the developers, genuinely thought that they would build those things, but then because of planning permissions and some problems, they weren't able to. So the only limitation then is when you make statements about the future, generally you're not able to the truth of those, because no one knows what happens in the future. The only limitation is it must be a genuinely held belief. So if in Chao San San the sellers, the developers, had never even considered building those tennis courts and they just kind of made it up, okay, then they might have had a problem because they basically lied right from the start, but that was not the case. So that's sort of the distinction there. But generally, statements about the future, so long as you genuinely believe them to be true, cannot amount to misrepresentation. All right, and then the third one, so the first one is must be a existing fact, the second one is must be untrue, and the third one is it must have induced the contract. This one's, I guess, fairly straightforward because, well, we have a case, Atwood and Small, and so what happened in Atwood and Small is that someone bought a mine. So when you buy a mine, you want to know what can you extract from the mine, how much is in there of whatever it is, or if you buy any sort of resource like that. And the seller gave a figure. Now, if the buyer had relied on that figure, then, well, if that figure turns out to be untrue, then that would have been misrepresentation because the buyer would have relied on that figure from the seller. But in Atwood and Small, the buyer did something more. The buyer brought in their own expert to check out the numbers, check out the figures. And their own expert didn't spot the mistake. They thought the figures were fine. So in the end, technically speaking, the buyer relied on their own expert rather than on the statement of the seller. So the statement of the seller did not induce the contract. All right, so I see someone's stream has stopped. I hope that doesn't apply to everyone. My own, I have a little screen here on the side, so my stream seems to be working. Ah, okay, there was a little gap there, so I think we're back on now. All right. Okay, we're back on. Sorry about that. Oh, now we stopped again. Don't know why it's sort of causing these these problems. Sorry about that. All right, so we got a question about the exam questions being mixed. Well, so let me get to that at the end in terms of what the exam might look like and what to expect. So let's just get through our topics first. So we had misrepresentation, and there's a 3-part test, and then there's 3 different types of misrepresentation. And depending on what type of misrepresentation is, you either have at your disposal in terms of remedies rescission, where rescission means you go back in time, you kind of unwind the whole procedure, all proceedings, or potentially you don't get to rescind, but at least you get to have damages. So those are the 2 options. All right. We then had illegality. I said under illegality, we're not going to do illegality under common law. So we're going to do illegality under statute, potentially. So you should look at that. And illegality under statute is essentially either illegality under statute of an express provision or an applied provision. Express is very easy, because express basically just means that you have a law, a legislation that says so-and-so contractual behavior is not allowed. So we had the Mahmoud Isfahani case, so the selling and buying of linseed oil is not allowed. So if the actual statute talks about selling and buying, it talks about contracts. So that would be express illegality in the statute of an express provision. The tricky one is the implied provision. So where the statute does not talk about a specific contract that's prohibited, the statute just prohibits behavior. And so we have a 2-stage test. And the 2-stage test is essentially the question of, first of all, whatever happens in the contract, does the statute prohibit that kind of behavior? Number 1. Number 2, does the statute not only prohibit the behavior, but also contracts involving that behavior? And this is not easy to sort of sort out, because we had a number of cases, and you kind of have to just think a bit about it. It's not straightforward. I can't kind of give you a perfect test that you can apply. You just kind of have to think about it. But we had these cases, a pair of cases about transport and a pair of cases about a stockbroker. So remember, if the stockbroker operates without a license, then the behavior of not operating with a license is prohibited under the statute. But does it also prohibit contracts that might arise involving that stockbroker? And well, common sense would tell you that it should. Whereas in the other, that's Cope and Rowlands. Whereas in Leroy and Bracken, the stockbroker did have a license, but he didn't stamp every contract. So it's basically just cutting corners in terms of the stamp duty payable. And the court said, well, that's kind of a revenue thing, but that doesn't prohibit the actual contract itself. So that you kind of have to think about. And I think I mentioned this, where if it's going to be a situation where if there's a question on illegality in the statute, I want you to be really comfortable with, first of all, the cases we discussed, and also the test, and whether you've taken it on board, if you're really sort of comfortable with it. If you're not so comfortable with it, maybe just spend a bit more time trying to get comfortable with it, and in a worst case, maybe if you're not 100% comfortable, maybe do another question. It's just one of those things where this is not just rote learning. You don't just learn the cases and then apply them. It's more about whether or not you sort of really grasp the concept. That's probably the best way to describe that. Right. Then we talked about contracts in restraint of trade. That is easier in terms of the rote learning aspect, because you have a number of rules, and then you just basically apply those rules. So or test, I should say. So there's basically 3 tests. If you have a restraint of trade, first of all, you have to ask, is it a legitimate restraint? It can only be legitimate if it's about employment contracts, if it's about sale of business, or if it's about solace agreements. That's the first point. The second point is, how long is the restraint for? Is that reasonable? And the third point is, What's the geographic extent of the restraint? Is that reasonable? So you just apply the test and you apply the cases that you know in that respect. We talked about breach of contract. I want to spend a bit of time on the innominate terms again. So breach of contract, conditions, warranties, innominate terms, anticipatory breach. Conditions, very simple, Poussard and Spears. Things that go to the root of the contract. And the root of the contract you can imagine in the same way that we just talked about when we talked about common mistake. What lies at the heart of the contract? So someone's asking about that actually. There are 3 types of breach of contract. Okay, so let me just, I'll just rewind the tape for a minute. There are basically 3 types of breach. There's breach of a condition, breach of a warranty, or breach of an innominate term. Those are the 3 types of breach. Now those 3 types of breach apply when they usually apply when the contract is due for performance. Sometimes those breaches can occur beforehand. That means before the contract is due for performance. And in those cases, it would be called anticipatory breach. So it's kind of a 3 plus 1. Now, with the anticipatory breaches, you have to bear in mind that yes, at the heart of the anticipatory breach also lies sort of a condition or perhaps an innominate term, perhaps a warranty. But the point really about the anticipatory breach is whether it is serious enough to terminate the contract or not. And that's where the party, the victim, basically has to make that choice. So if the other party commits what you think is an anticipatory breach, so they breach the contract before it's due for performance, then you have to decide whether you think it's serious enough to terminate or whether you think it's not serious enough and you're not allowed to terminate. So that's sort of the decision you have to make. So basically, if there's a breach of a condition before the contract is due for performance, you would be able to terminate, and then it would be an anticipatory breach. So when I say 3 plus 1, so the three types of breach are condition, warranty, innominate term. Okay, we can put that in so one basket. Those are the 3 types of breach. And anticipatory breaches, they incorporate those 3, but they're a special circumstance, namely whenever a breach occurs before the contract is due for performance. All right, so let me just get back to conditions and warranties. And so conditions are things that go to the root of the matter, the heart of the contract. So if you don't do something that you promised to do, and that is part of the contract, like in Poussard and Spears, Mrs. Poussard not singing in the actual concert, well, that goes right to the root of the contract, so that's a breach of a condition. If you don't do something that you promised to do, but it doesn't go to the root of the contract, then it may just be a breach of a warranty. And the case we had, of course, was Bettini and Guy, where the guy didn't show up for the rehearsals. And the rehearsals, the court felt, didn't go to the root of the contract. They were important too, but they didn't lie at the root. And then the difference really is, if there's a breach of a condition, you can terminate if you want to. If there's a breach of warranty, you cannot terminate. You can only claim for damages. Condition, you can terminate and claim for damages, or just claim for damages. That you can decide that. Now, I said I wanted to talk a bit about the innominate terms. So innominate terms are kind of in between, and they're important because for a long, long time there were only conditions and warranties, and there were no innominate terms. And then in 1962, the innominate terms came along through the case of Hong Kong Fur Shipping. Now, what's crucial about innominate terms is that ultimately they are also about either conditions or warranties. So ultimately, at the end of the process of considering the innominate term, we end up with either a condition or a warranty as well. So in that sense, nothing has changed. We still have conditions or warranties. But there is a crucial difference, and that is that normally, when a court considers whether a clause is a condition or warranty, what the court does is it goes back in time. It's the kind of reasonable man test. What would a reasonable man have thought had the reasonable man have been around when this contract was negotiated? And it's basically an interpretational question. And then the reasonable man could either say, well, this would have been a condition, this would have been a warranty at the time that the parties were kind of talking about these things, negotiating their contract. Now, Innominate terms arise because sometimes, even though the court can apply that sort of thinking where they send the reasonable man back in time, sometimes the reasonable man cannot come up with an answer. It's just impossible. That's because sometimes you don't know whether a breach amounts to a serious breach or a minor breach, or a condition or a warranty, unless and until it actually happens. And so in Hong Kong First Shipping, the clause said, of the contract stated that the ship at issue had to be seaworthy. And the court just held, well, we can send a million reasonable men or women, reasonable people back in time, and there is no way of determining whether a breach of the seaworthy clause is serious or minor. There's just no way of telling unless the breach happens. So it just gave rise to a separate type of clause in a way, or a separate type of breach, not clause, breach, which the court then said, named innominate term. So a breach of an innominate term. And the real difference lies only in one thing, and this is the most crucial point. An innominate term is a term that we cannot tell whether it's a condition or a warranty until and unless the breach occurs. Only once the breach occurs do we know what it is. That's really the crux of the matter. That's the heart of the whole thing. And when that breach occurs, and then we do know whether it's serious or minor, we don't call it condition or warranty to distinguish it from the ones that we knew beforehand. So to distinguish, we call it a breach of an innominate term with either serious consequences or a breach of an innominate term with minor consequences. So that essentially is what these innominate terms are about. And the interesting thing about that is that at the time, that was very revolutionary because, for a long time, the common law, contract law had operated with conditions or warranties, and suddenly there was this new thing. So that was very revolutionary. But so in reality, it probably turned out to be less significant than may have been thought, for one very simple reason. I mean, it's still fantastic from a sort of an academic's point of view and a common law development point of view, and a brilliant judgment. It's really wonderful to read. But in the real business world, what happened was that parties don't want to have this uncertainty. So what they would do is they would simply predetermine everything. So they would say, this ship must be such and such and such and such. They would just write everything down, and contracts grew and grew longer. And in fact, in Mihalis Angelos, which was a few years later, something like that happened because the parties had agreed in that case that if a ship was not ready for loading, then the party who was providing the cargo was able to terminate. That's what they wrote down. So the parties actually wrote that down in their contract. Now the ship was not ready for loading, as it turns out, but the cargo wasn't ready either. So if it was an innominate term, then it would have been completely without consequence. So at the very, very worst, it would have been very, very minor. So shouldn't have led to termination. But the court in Mihalis Angelos said it's not actually an innominate term because the parties have already predetermined it. If they hadn't predetermined the consequences, namely termination, then it might have been an innominate term. But because they did predetermine, it turned out to be a condition. So, in other words, to avoid the uncertainty which innominate terms can throw up, what you do is you simply predetermine everything as the two parties in a contractual relationship. All right, so we have a question about anticipatory breach. All right, so examples of anticipatory breaches. So, for instance, the Mihalis Angelos is an example of, the case we just talked about is an example of an anticipatory breach, which could also have been perhaps an innominate term, which could also have been, as it turned out, a condition. But we just call it an anticipatory breach, which is either valid or validly taken or not. That's really those are the two options. So in Mihalis Angelos, because the breach, which happened before the contract was due or before this particular clause was due, because that breach was serious as determined by the parties beforehand, the anticipatory breach was allowable, or it allowed termination. So remember what happened in that case. A ship was supposed to be ready for loading on a particular day. It was clear through 2 or 3 days earlier that it would not be ready for loading because it was supposed to be in Vietnam on a particular day, but it was still in Hong Kong, which is a few days sort of sailing away. And it was just physically impossible to get the ship there in time. It would have just not gotten there in time. So that's an anticipatory breach because although the performance date has not arrived yet, you know that it's not going to happen. It's just not going to happen. So you can then, as long as it's serious enough, you can terminate right then and there. In other words, you don't have to wait around to see if the ship might still come because it's not going to come. It can't make it. It's physically impossible to make it. And of course, the main case we had for anticipatory breach was Hodgster and de la Tour, an old case where this guy Hodgster was employed as a messenger who was going to go on a trip with de la Tour to Europe and kind of just operate as a messenger. Now, before the trip ever started, the de la Tour said, "Oh, I don't need you anymore," to Hodgster. So a couple of weeks beforehand. So there's basically then two options, isn't there? Hodgster can either wait for 2 weeks, show up at the agreed time and date, and be told, "No, we don't need you." Okay, and then he would have done what he promised to do, and the other party would have not done what they promised to do, and so he could have then claimed termination and compensation. However, what Hodgster did is, when he was told he was no longer needed, he went straight to court. He basically made his claim right away, and the sort of the novelty of that was that the performance date hadn't come yet, because there was a risk where the court would have said, "Well, you're too early. Why don't you wait for 2 weeks? I know you've been told that you're not needed or whatever, but look, the performance date hasn't arrived yet. Why don't you wait, go to the agreed time and place in 2 weeks' time. If you are still not needed then you come back to court." Okay, that's sort of the option where you wait until the performance date arrives. But of course, the court, as it turns out, the court agreed with Hodgster that he was able to sue for anticipatory breach right away. So you don't have to wait for that date to arrive. All right, so that was breach of contract, and then we moved on to frustration, which will also be our last topic that we're going to discuss here, because the remedies worksheet I've excluded. So I'll just briefly talk about frustration, then I'll come back to the questions about the exam. So frustration is a fair, I think, in my view, is a fairly straightforward, a nice area of contract law, because there's two things that you kind of need to, two broader things that you need to think about or talk about. The first one is the sort of historical aspect of frustration, which is very interesting in and of itself. It's probably a bit more academic than the actual application, but it's nonetheless very interesting. So in frustration, we started off in the common law without that sort of doctrine. It just didn't exist. And we had a case, Paradigm Jane, where someone had leased some land. The land was then occupied by military forces, and they still had to pay the rent, even though they couldn't use the land. And the court said, well, you have freedom to contract. You could, if there was any risk that the land might not be usable, you could have just agreed that in your contract. You could have talked about that in your contract. You didn't talk about it, so you have to pay the rent. Okay, so no frustration, no doctrine of frustration. Then in 1863, in Taylor and Caldwell, which was about renting a music hall, and the music hall burned down before it was supposed to be given to the party that was renting it. The court did accept that there was this thing called frustration, that there was a doctrine of frustration, and it applied basically a two-stage test. That means sometimes frustration basically means a contract comes to an end because of an intervening event or something that happens that's sort of unforeseen. So like a music hall burning down. And the court said, well, as long as neither of the parties burned down the music halls, it's not their fault. So as long as it's not their fault, and number two, so long as it's a drastic change in the circumstances, that should then allow a party to basically walk away from the contract because the contract is frustrated. So basically, the parties are then, from that point onwards, no longer bound by what they promised under the contract. So they no longer have any duties under the contract. And then that sort of, you could imagine that sort of opens it quite widely, and because by the way, this concept was imported from the civil law tradition. into the common law, that opens it quite widely, because you can come across a lot of situations where circumstances change and it's not the fault of either of the parties. And then you say, well, sorry, I'm going to walk away when we don't have a contract anymore. And so the courts have rolled back a bit, about 100 years later, in the famous case of Davis Contractors and Ferrum, because that's where the court said that instead of having just this two-stage test, what we ought to have is we ought to investigate a bit further, inquire a bit further. So essentially, they came up with a three-stage test, and the three-stage test is the first two are essentially the same. Was any of the parties at fault? If the answer is no, then you move on and ask, have the circumstances changed? Have they drastically changed? If they have, you then have to satisfy a third part, so it becomes a three-stage test, which is not only do the circumstances need to have changed, but the underlying obligation under the contract must have changed as well. So if you apply the three-stage test to Taylor and Caldwell, of course the circumstances changed because the music hall burned down, but the underlying obligation, depending a bit on the wording of the contract, would have been to provide such a hall. And the underlying obligation may still have existed, even though the music hall burned down. So potentially you would then go and, as the landlord, have to find another hall which you provide to the tenant. So it became a three-stage test. All right, let's see. Remedies, okay. So this is about, the next question I see here is about the exam. So, all right, frustration, we have, let me just finish this on frustration, I'll come back to your question and the other exam questions. So for frustration, we have the three-stage test. You just apply the test. For each of those stages of the test, we have cases that sort of try and delineate how that works. So have a look at that. And then, broadly speaking, frustration can be grouped into 5 categories of frustration, the ones we talked about. So, as I said, for frustration, you basically think of it, there's sort of 2 things to know about that. The first is the historical development, which is very interesting in and of itself. Second is the actual application, which is, there are these 5 categories, and for each of these 5 categories where frustration might be available, you apply this 3-stage test. So that's essentially those are the topics that we talked about. Those are the topics that might be covered in the exam. All right, so now let's talk about the exam. So the questions I see here, I'll just start with the last one, is about the remedies, where I said that I'm not going to examine you on the final worksheet. And so I want you to think of it that way. And by the way, when we finish here today, I'm going to send out a message for all, especially those people who are not able to watch or who are not able to attend on Monday night, because I want everyone to, even if you weren't able to attend, have the benefit of what I said on Monday night and what I'm going to say now, which is I've excluded a worksheet. So that means whatever that worksheet says, I don't expect you to know that. I'm not going to test you on what that worksheet says. But if remedies are mentioned in another worksheet, so I remember, for instance, in the misrepresentation worksheet, there's a lot of stuff said there about remedies. So whatever is on that worksheet, which is I think worksheet 2, well then you'll need to know that, because I haven't excluded worksheet 2. I've only excluded worksheet 5. All right, so that's in respect of the remedies. In respect of the, and I think worksheet 6 is excluded. 5 is frustration, so that's included. Anyway, I'll send you, I think 1 through 5 are in and 6 is out. And worksheet 4, I think, has quite a bit on remedies as well. That's the breach of contract one. All right. Other questions that were asked earlier about the exam are mixed questions. Well, you know, yes, they might be mixed. I don't know. I mean, I can't remember, but that's always a possibility. So there will be some that are not mixed, and there will be others that are mixed. That's just sort of, for instance, when you talk about frustration, it's got to be mixed. I can't influence that, because if it's not frustration, it's breach of contract. So the two of them are totally intertwined. You can't separate them. But for instance, maybe there might be a question about misrepresentation, and then that would be just simply misrepresentation and nothing else. So it's just you just have to sort of keep your eyes out for that, and there'll be some that are mixed and others that are not mixed. And let me just scroll up to see what other question we had on the. There was a bit more on the exam, wasn't there? Okay, oh, just the topics, and the question about the topics. So I'll send a message to everyone just to confirm the topics, but in a nutshell, it's worksheets 1, 2, 3, 4, 5. You need to look at those and learn those. And worksheet 6 is I'm not gonna examine you on that. And so the format of the exam, just to also just say that again to be clear on that, if you you got to do 3 questions. You got to choose 3 questions. So you have 2 hours, and you got to answer 3 questions in 2 hours. And you have to choose those 3 from amongst 6. So you will get 6, and you can choose any 3 you want to. So there won't be anything compulsory. There also won't be a sort of a part A, like 1A, 1B, nothing like that. So it'll just be 1, 2, 3, 4, 5, 6. And then you just choose any 3 you want to. And 4 of those will be essay questions, and 2 of those will be problem questions. All right. I think that's pretty much it in terms of what I wanted to talk about. Are there any other questions that you have? All right, well, thank you very much for your interest, and also sorry again about these problems with the stream. I can't say for sure whether it was on my end or your end. I know that I had a brief, I have a little, I've got a separate little computer here just to see what's going on, because I want to see that the actual stream works, and it froze for a little while, but that was just one little freeze. So if that happened, or if it froze altogether for you or whatever, apologies for that. But this is the first time we're doing this, first time for me too, so it's kind of a little experiment, and just wanted to kind of see how things go. Oh, so we get a question about the exam's worth. Well, each question is the same, so each question will be 33.3 marks. Well, in fact, the way the answer guide works is each question is 34, marked out of 34. But of course, once you've achieved 34 once, which I hope some of you do. It's difficult because you got to get a lot of get a lot of things right. In essence, you have to get everything right. But it happens. It happens, and whenever that happens, I'll give 34 marks for whatever I go through, and give it 34. But then, of course, the next one we just marked out of 33 because you've already kind of achieved the maximum there. But so technically, when you look at the exam, it will have a question, and then right after the question, it will say 33.3 marks. So each one will have 33.3 marks. All right, so I see we've come up to 7 o'clock, so we've filled the whole hour, and it wasn't, I'm not sure I expected that we would do that, but well, thank you for your interest, and as I promised, I'll send everyone a message just to detail exactly the topics that are going to be covered and the ones that are not going to be covered, the ones that I've excluded, just so that everyone has that benefit. And if you have any other questions, you can approach me, you can email me, you can send me stuff. So some of you have sent me stuff, and then I've responded with comments, like you can take a past exam question and try and answer it, and then just send me whatever you come up with, and I'll tell you how well you did. So, you know, all of that's possible. I'm very open to all these suggestions and all the submissions, whatever it is, and just let me know. All right, thanks very much. Have a good evening, everyone.